Collins & Co.'s not-for-profit conference, Be Empowered Through Knowledge, is designed specifically for the not-for-profit sector. Our speakers are experts in this sector, and their practical approach provides not-for-profit board members and management with the opportunity to improve their skills and knowledge across a range of specialist topics. The conference also provides a great networking opportunity. Partner Fabio Camerano introduces our next speaker.
Kate Hamer, who is the principal lawyer and trademarks attorney at Ethicate. Ethicate is a specialist brand protection and intellectual property law firm, founded on integrity and with a rebellious and fearless spirit to push the boundaries of conventional legal practice. In an industry where there is highly conservative and set on tradition, Ethicate dares to be different. Kate has a strong commercial background, acting in both commercial and legal roles for over 10 years. So without further ado, please welcome Kate.
Hi everyone, I know that lunch is coming up, so I thought I'd just pop some chocolates on your tables, and also last year I ate all the leftover chocolates, so I thought it would be in my interest to just hand them out. Thanks for coming along today. As you can see, I'm speaking on, and hopefully this will work for me, common risks of going online. So obviously this affects all organisations, whether you're a not-for-profit or a private organisation. Just to sort of capture what we're going through. I guess we're going to talk about some key risks. There's heaps of risks and there's a lot of different areas that I could talk about, but that's not going to happen in 1 hour. So what I'm going to focus on today is trademark and copyright infringement, which affects not-for-profit organisations all the time. Believe it or not, NFPs are one of my biggest practice areas. We're also going to talk about Australian consumer laws if you're in trade, and believe it or not, NFPs are deemed to be in trade, then you need to be aware of what those consumer laws are. And we're also going to talk about it in relation to confidential information and privacy. So it's not my intention today to cite legislation or case law. I'm just going to talk about it from a practical perspective. But feel free throughout just to ask me any questions. And there'll also be a bit of time at the end. This way. All right, so where's the risk? Now, obviously, I would expect all of you would have a website. There's the website content. There's also your domain name. Then when you're talking about social media, that's obviously a huge risk area. And the most common ones, you've got your Facebook, Instagram, LinkedIn and Twitter. And I'm also going to briefly mention SEO and AdWords. It's probably not something a lot of you actively pursue. Out of interest, does any of your organisations use SEO strategies? Okay, a few. Yeah, it's becoming more popular. And AdWords, well, sometimes that can be a risk as well, particularly when you're talking about trademarks and the type of words that you're using to attract your donors. Search engines, so your Google, of course, and then, accessing third-party websites. And obviously there's some risk now with cloud software. I think the important thing to understand when you're talking about going online is it's still the same concepts, there's still the same risks, it's just shifted into a different area. So all these things that I'm going to be talking about today still affect you offline as well. But I guess it's more prevalent and, a little bit more sexy to talk about it in the online world, which is why I'm covering off on it. But it certainly does apply whether or not you're operating online. And the other thing to just think about as well is that there's two aspects that you want to be aware of. There's the risk to your organisation where you've got internal people doing the wrong thing or not. Usually it's just a pure innocence, it's a lack of understanding. So there's a risk of infringement or a breach from that end. And then there's also the risk from the other side where you've got other parties who might be doing things that they shouldn't be doing. And the last thing a not-for-profit organisation wants is their reputation to be affected in any way or to have their funds wrongly diverted to another organisation because of things like trademark infringement or misleading or deceptive conduct. Okay, so what's IP? We're going to talk about trademarks and copyright now. So your trademarks are your signs used in trade, your badges of origin. everybody just says it's a logo. Yep, that's an important part of your brand, but it's your brand name. So it's your organisation name. It might be some images that you use. It could be a combination of those, which is often referred to commonly as a logo. It can be your colours. It can be your packaging if you sell products. It can be a whole range of things. So there's no limit to what a trademark is. It's essentially what people identify as your badge of origin. So, when you look at it in the corporate space, you see Apple computers, or you see the Apple sign, you know instantly the source of that product, and it instantly gives you that sense of the quality and the type of product that you're going to have. And there's also, Apple are a fantastic example of an organisation that creates a really emotional connection. You think about pink. Hands up when I say think pink, what are you thinking about? Yeah, exactly. So that's a huge part of their branding. So it's really important area, and it's actually a huge practice within not-for-profits. And I think that one of the biggest issues you'll face is that a lot of you will use very similar brand organisation names to thinking that describing what you are is important. And what happens is that can cause a lot of confusion between the different organisations. And then copyright works. So copyright is your artwork, it's your logo design, it's your web content, it's articles, it's blogs, it's videos, it's any original and creative expression. So it's not a tagline or a word mark like your brand name, but it's anything that goes a little bit beyond that. So, and it can also include a whole range of documentation within your organisation as well. Now, just in terms of trademarks and copyright, both of them, the benefits is that you get exclusivity. So when you have a registered trademark, you are the exclusive rights holder and no one can use anything similar. And same with copyright. The benefit with copyright is that it's created automatically. You don't have to go out there and register it. And if you get one of those letters in the mail, then please ignore it because there is no registration system. And you're also you have the exclusive right to reproduce that material. So if you have an image that you have created within, you've got an in-house photographer or you've acquired it appropriately, and I'll talk about that because you may not be the rights holder, then you have the right to publish that, to reproduce it online. No one else does. So just in terms of registered and unregistered rights as well with the trademark, we'll talk about that a little bit later. But I guess the focus is that, it's really important with your brands that if you do have a registered trademark, then it's a really great defence to trademark infringement. And when you're a poorly resourced organisation, which is most small businesses and NFPs, then spending that small amount of money to get your trademark registered will provide you an instant defence against trademark infringement. So no one can take you to court for any of those goods or services that you're protected in. And I can talk, if you have questions about that, come and see me afterwards. Sorry, just go back quickly. And I just also want to mention as well that trademarks is by country. So if you've got a trademark registration, you'll be protected most likely in Australia. If you have a global organisation, you may need to look at seeking protection overseas. Global protection is recognised in relation to copyright. So whilst you might create a copyright works over here, there is convention that recognises works that are created somewhere else. So, if there's works that are created, for example, Walt Disney Corporation creates something, yes, it is copyright protected and recognised basically globally. And just a couple of myths as well about trademarks and copyright. A lot of people say to me, oh, I've got my business name, I've got the organisation name registered as a business name. Hands up if you think that that's sufficient. Probably no one's game to say yes. It's not. So it's really important to understand that the name of your organisation is a compliance matter, things that Derek, who was speaking earlier today, will help you out with. It doesn't give you any exclusivity or ownership rights. So sometimes we go and register a business name or an organisation name, and we might even go out there and get the domain names and think that gives us some kind of exclusive rights, or we can go out and use it freely. Well, you can't. So it's something really important to think about. Another really common myth, if it's available online, it's free to use, free for all. Or if I use a certain percentage of something, then I'm covered in terms of copyright. I'm not even going to ask you. Essentially, both of those it's a myth. So there is no such thing as a percentage. You can forget about that. It's all about the content and the quality of the content that you're copying. So it could be as simple as one sentence of a book if that sentence is so original and such a substantive part of that. And obviously, don't copy images off the internet. It's one of my biggest practice areas, unfortunately. Without having the proper licensing rights, you need to make, you're really putting your organisation at unnecessary risk when essentially all you need to do is pay a couple of dollars to get some stock photos from a legitimate website. This has gone to sleep. Okay, so we've covered a little bit about trademark and copyright infringement, and I guess the most important thing to understand when it comes to copyright infringement, it's essentially using material without authorisation. And authorisation really needs to be in writing, preferably in a contract, but at least get the permission of the rights holder and make sure you actually know who that is. So it's all good and well for someone to tell you can use something that they've taken off their website, but how do you, where was it sourced and how do you know whether they actually have the rights to be passing over to you? The other thing is attribution. There's a thing under copyright law called moral rights, and you can't transfer it. An organisation can't own it. So whoever creates work for you, whether they're a volunteer, a contractor or an employee, they will always maintain the moral rights, and that's the right to be properly attributed for the work and not to be incorrectly attributed. So photographers are a great example of people who like to have proper attribution. Some things, like if you've got staff members who are creating compliance documentation or internal policies, there's a recognition that there are no, that you won't be attributed for that individually, but there's a lot of grey areas, so it's really important to kind of understand, I guess, that there is that moral rights aspect as well. Copying ideas versus content. So what I'm talking about here is that you might all have an idea to do something. So everyone might have an idea and say, look, I'm going to go out there and take a photo of the MCG. Well, that's fine. Everyone can have that. Everyone and anyone can have that idea, but the way that photo is going to be taken is going to be unique, and that's the expression of that idea, and that's what's copyright protected. So, I hear all the time, well, someone's come up with a fundraising campaign and someone else has ripped them off. Well, they haven't. They've ripped off the idea and nobody likes that, but unfortunately, unless they've ripped off your content or expressed it in the same manner that you have through their marketing collateral, then they're entitled to. Okay, and the other important consideration is in relation to using freelancers and third-party websites. So, everyone these days is using Elance and all those cheap, what's it called, Fiverr. Don't even put your hand up, I don't want to know. If you're using Fiverr, but Fiverr's a website, if you haven't heard of it, that creates logos. You can put it out there for someone online and it can cost as little as $5. It's fantastic if you are using something for a low risk or for internal purposes, but if it's something that's going to go out there in the public domain, and particularly if you want to source sponsorship and in people to come and sort of be a part of you from a corporate perspective, then having having a logo that's been created that you don't even know if you're the actual rights holder of it or whether it's a legitimate one that's your own copyright material is a real risk. So an important thing to know is that unless they're an employee of your organisation, you won't own the copyright in any material that's created for your organisation. Same with other IP rights. So the important thing that you need to make sure you have in place is some really good terms that are in writing, preferably signed, that says that they assign all of the copyright across to you. So that includes volunteers and any contractors and service providers. And the last one, which I mentioned really briefly before, and I won't go into too much, is the domain names, AdWords and SEO. I said before, domain names are not a trademark right for most of the time. There are organisations like realestate.com.au that is recognised as a trademark, so sometimes a domain name can be, usually if they've built up sufficient reputation. And so it's really important to make sure that, when you're going out there and using, registering different domain names or that sort of thing, that you're not going out there and trying to register any similar ones to your competitors or your colleagues. And AdWords and SEO as well. So there are cases that say that using trademarks in your AdWords can be trademark infringement. So even though it's behind the scenes, if it wrongly attracts people to your website, then you need to really tread carefully. The only way around that is if you've got you're using words that are really descriptive and they describe what you do. So that's a way around it. Okay, so we've covered off on most of this. I just want to mention brand clearance searches really quickly. So a really great way, I guess, to get some peace of mind for your organisation when you're coming up with some branding or you're going to launch a new campaign, or you've got somebody to create a great device or an image for you, is to get clearance searches. So it's to just check whether or not just for trademarks, but we can check for images as well, and to make sure that there's nothing out there that conflicts or that comes up that might pose a risk to your organisation. And it's also a really great way to gauge whether or not you've got good prospects of getting a trademark registered as well. So when you're first starting out and you haven't, if you haven't been using that particular brand for very long, brand clearance are a really good idea at that point in time. And obviously, I mentioned before, get trademark registration. It's not only creates a valuable asset for your business, which wouldn't otherwise be recognised as an asset, it's only recognised, an unregistered trademark is only recognised as through goodwill and reputation, and it can be very localised to only the particular area that you're operating. But it also gives you that exclusivity and the peace of mind that you've got a defence to any claims of infringement. Plus, corporate sponsors love it. So if they're going to be using your branding, then they're going to want to know that you have the appropriate clearances and that they're not going to be at risk, because whilst it may not be very good publicity for an organisation to come after a not-for-profit, it's kind of, nobody really feels sorry for the big corporation, so who's well-resourced and can pay the damages. So just, keep that in mind, that most organisations, when it comes to providing any sort of sponsorship, will want to know and have assurances that you own all of the IP and that you have trademark registration. So we've covered off on most of that. Does anyone have any questions about that slide, or we'll skip past it? Here's a few examples of some trademarks. So it's not just about registering a logo or registering a word. You can register all sorts of things. So the best way to protect a brand, I think, is to separate all the elements of your brand up and register them separately. And then that way you can use two trademarks together, or you can use them separately so they don't become codependent. If you register a word mark, for example, you can use it in any colour, style. It doesn't matter if you update your logo, and it gives you the strongest protection for those words. If you add an image to it, like the Cancer Council, you add a little device to that, then it dilutes the value of the protection in the word. So it's, trademarks are seen as a whole. So there's just a couple of very small examples. Again, how to protect your copyright. Well, as I said before, make sure you own it. You may not actually be the owner of your copyright material. It happens a lot, particularly with volunteers and service providers, and you'll be in a much better negotiating position to get them to sign it over at the start than later on. So we've had, and I've even worked with organisations who are not-for-profit, who've unfortunately had graphic designers later on tell them that they own the copyright and they have to pay additional fees to be able to have it transferred across to them so that they can make certain changes to their logos. And I think it's putting aside the ethics in that, the reality is that graphic designer had every right to make that claim, that request. I've had clients in the private sector who haven't done their checks and balances, and when it's come time to sell or merge, they've had to pay out fees to graphic designers in, as much as $250,000 to get it settled, because they knew, smart graphic designer, that they had a meal ticket there. So, and the costs of settling was, nothing in comparison to what would have happened if they didn't go through the full settlement for the merger. Some other things to do, you don't have to, but use copyright notice. Most people don't want to do the wrong thing, and when they've got it in their face, they will make a decision not to do it. So put the copyright notice on, and make sure that when you do put the copyright notice on, that you put the year of creation of the works, not the current year. So it's the year you created the work, is the year that you'll be protected from. Okay. You can watermark images, so when you're using social media and you're distributing material through Facebook or Instagram, for example, then why not watermark your image or put your brand on it? And if people want to then reproduce it, then it's great, free publicity. And I think have a copyright policy, or more broadly, have an IP policy. Something that makes it really clear what your internal people need to do, and then also what your external people need to do. So when you're providing consent to, say, for example, subcommittees or other organisations that are related to you, and you're allowing them to use your brand, then make sure you control that use. So it's only going to enhance your reputation anyway if you're doing it properly. And I think we've covered off on most of that. There are some great tools online as well that can help pick up plagiarism. So if you are outsourcing or getting third parties to create content for you, you can use online programs. I think one that's just become free is called Grammarly, and it will do a search of the material and provide you with sources that it believes that material has come from through the internet. So it might tell you that it'll pull up extracts from, say, Wiki or something like that, or Google. So that's a great tool. And make sure, again, that you get the copyright assigned in your work. Yeah, sure. Yeah, absolutely. Yeah, if they're employed by you, there's an assumption that, there's a provision under the Copyright Act that says that the work that they create, and make sure this assumes that it's in connection with their work. So if you've got a cleaner and they come up with a new concept, they're not engaged by you to design, new campaigns, then they're going to own the copyright. But generally, if it's in the connection with their duties, then as an employer, you'll own it. And then if you're using contractors or volunteers, then the assumption is that they own it. Yeah. Oh, yeah. Yep.
It's not to do with NFPs, but I've had a situation where a couple of people were using a very similar logo,
Yep.
and one of them tried to claim property rights to it and ended up in VCAT. I don't exactly know what the situation was at the time, but does that apply to NFPs as well?
Yeah, absolutely. I'm not sure. I don't know. I'm not quite sure what would happen within VCAT, but yeah, generally a logo potentially has two rights. It has copyright in it if it's got quite a unique design, so if there's some artwork in it. And then if it's a registered trademark as well, then you've got trademark protection. And if anyone's using something, it doesn't have to be identical, it could be deceptively similar. So something that might cause people to be confused or divert, funds from one organisation to the other incorrectly. There's also other provisions too, like misleading or deceptive conduct, which we'll rush over to now. So absolutely. Okay, so consumer laws and passing off. So misleading or deceptive conduct, has everybody probably heard of those words and what they mean? And then passing off, which it's actually very, very similar in many ways to consumer laws, but it's a very archaic, sort of an old school way of protecting unregistered rights. Essentially, the point that you need to take away from that is that you can't make statements or you can't engage in conduct that might be misleading or that might somehow deceive people. For example, if you wrongly infer that you have sponsorship with someone or an affiliation with another organisation, then that could be misleading or deceptive. It could also be passing off. If you have a great campaign and somebody else goes out and does something similar or uses even the brand that looks similar and people think, well, hang on, what's going on here? Is that a sub-organisation or is that the South Australia equivalent? Then that could be considered to be passing off, and it's potentially causes damage to the organisation's reputation, particularly if that other organisation isn't providing a good service or doing the wrong thing. And it really does devalue the hard work that you've put into protecting your brand and dilutes the sort of value of your campaigns. The other thing that I've mentioned down the bottom is your terms and conditions. So a really common thing that I have happen all the time, quite ironically, is people copy website terms and conditions and put them and then bring them in for me to review. And I know they're copied because they have the laws of California as governing the terms. And I sort of say, oh, I didn't realise you wanted to, I'm quite happy to go over to California and to enforce your rights. But it's really important when you're, offering anything and promoting your goods or services, whatever that may be. And as I said before, an organisation, even in a not-for-profit, is considered to be in trade. For the purposes of some of these acts, you need to make sure that you've got terms and conditions on your website or that you're offering terms that are correct, that are up to date, that aren't onerous. You don't want to take on obligations by, that you don't understand or that might even void your insurance policies. And just be aware too that there are some new laws that are coming in November under the consumer law, and it's getting a lot more rigid. So even when you're dealing now with small business organisations, there's a whole lot of unfair contract provisions. So I guess to take away from that, just make sure that whatever that you really are have some proper terms and conditions that are valid for the jurisdiction that you operate out of, and that are up to date, and that aren't going to make you have to agree to do something that you don't actually really want to do. I've had this issue a lot lately. Okay, here we go. So how to be compliant with the ACL? Well, again, I'm not going to go into it, but brand clearance searches can help you in terms of understanding whether or not you're using brands that might be similar to another. Now, this is, I didn't really know how else to put this. It's, for the most part, it's common sense. Just don't mislead or deceive. If you want to sort of cross the line or you want to come close to the line, get some legal advice, because it's just not worth it. So, I don't think most not-for-profit organisations aren't going to behave like that. It's usually in the corporate space, to be honest, and they might be using large events or they might be using other organisations and do a play on words. So hopefully you're all kind of, work in an ethical space and you're not probably going to be coming close to that line. But if you're unsure, don't do it or get some advice. Confidential information. Now, Wayne, if you were at the session just before me, sort of touched on this. Confidential information, essentially it's information that that isn't publicly known, so it's not out there in the public domain. And it can be a whole multitude of things. So it can be certain information about clients, volunteers, your contacts within those organisations. It can be all sorts of concepts for new campaigns that might not be yet released. It could be, obviously, the finances and operations, marketing plans, business plans of the organisation. Now, the important thing to to understand with confidentiality is, I guess the main thing is that you don't want information to be disclosed that doesn't need to be disclosed. So if you're on a board, don't go and disclose it to people. It's a needs-to-know basis. So the best way to start off is to not disclose things to other members of your organisation unless they need to know it. You can also have confidentiality deeds. So usually most employment contracts will have a confidentiality term in it. You can also get them, so if you're going to go and talk to potential sponsors, or if you're putting different pitches out there for campaigns, then you can use a confidentiality agreement. It's important to get it signed off on before you actually disclose the confidential information. So there are some not-for-profit organisations or social enterprises who might come up with a new product. If you have that conversation before you get the confidentiality protected, then what you're actually doing is putting it at risk that it's now into the public domain. It's no longer new or novel, and you can't protect it through other means like patents or designs. Yes?
Does that include declaring a conflict of interest?
Yeah, that's not necessarily confidential, but yeah, if you're talking about in terms of whether a board member, for example, knows of a potential conflict that they might have, and that potential conflict might be confidential and they can't disclose the details of it.
It's just like where they might be involved with 2 or 3 different organisations.
Yeah.
And we have a confidentiality agreement we sign with our board.
Yep.
So, and if you know that's going to be discussed, you then declare into the conflict of interest and leave the room when it's discussed.
Absolutely. Yeah, absolutely. And as lawyers, we deal with it on a regular basis as well. So it's a good tip if you want to get legal advice. Don't send me a 3-page email. Just make sure that I'm not conflicted to act for you first, because it's happened before and I've had clients who have the same trademark. So yeah, it's really important with conflict of interest stuff as well, that, yeah, those people are not involved or information isn't disclosed to them. Don't put them in that position. And again, have a policy in place. So have your internal policies to make sure that this information is being protected and controlled. Your confidential information is what I sort of call like your pre-IP. It's your ideas and it's your trade secrets. So it may not be protected by IP yet, but it's kind of that pre-IP phase. Okay, and I won't go too much in this. I think most people have a reasonable understanding of privacy law. There are a whole lot of exemptions under it, so, but just being an NFP in itself is not necessarily an exemption. There is some specific exemptions under the Spam Act. So, for example, where you're collecting information or you're sending it out to, you're sending out emails, you have a little bit more protection. But in terms of privacy, it's really important that if you make any privacy statements, that they're correct. So you don't want to have a situation where you can't then, if you're, example, going into a merger with another not-for-profit organisation, you want to make sure that you haven't said anything that will prevent you from being able to disclose that personal information to the new, as part of the new merger. And you also obviously want to have some policies in place to make sure that you have really strict procedures for protecting personal information. So, putting it back to the online space, the biggest risk we have is where we're storing information online through cloud servers. Dropbox is a great example. Dropbox isn't a secure portal unless you upgrade and you have a password. So that can enhance the ability to protect it. But otherwise, you shouldn't be uploading personal information, onto those sort of databases where if someone just happens to have access or can somehow find the URL, that they can access it freely. And, you don't necessarily, a lot of people think they have to have a privacy policy. Most of the time, unless you're actually an organisation that may turn over revenue of more than 3 million, for the most part, you're actually exempt. So you don't need to have a convoluted privacy policy up on your website. So again, don't take on additional responsibility or obligations that you don't need to. So just to... Oh, yeah. Question. Sure.
When clients attend an agency, and statistics have to be kept for funders, government ones, but there's no identifying information passed on. Do we still need to get consent from the clients?
That's a good question. And I'm going to be a lawyer and say it depends, but no. No, generally, yeah, you would err on the side of caution. You would normally need to, whenever you're collecting personal information, you need to advise them on how it's being stored and maintained. So if you are collecting information from them, that's when you would be sort of, getting that consent or advising them of through a policy or a statement, okay, this is how we collect information and then this is what we do with it and this is how we protect your personal information. So you protect it by de-identifying it. So, but again, it depends. You might be exempt from the Privacy Act and you may not have to go into a detailed description of exactly how you do it. You might have other obligations, so depending on how if you're collecting it for statistical purposes or if it's going through to an agency that's turning over a certain amount of money, that's a private organisation or that is going to be selling that information for any reason, then you would have to have a proper privacy policy in place. So it's a few factors to consider, but yeah, err on the side of caution. Don't take on obligations you don't need to, but be upfront about things and as transparent as possible as well.
Thank you.
Yep. Okay, I'm not going to read these off one by one. Does anyone have any questions for me at all? I'm happy to take them, or you can always contact us, and we've got the stand up the back as well. So, I just wanted to say thanks for listening to me, and hopefully that wasn't all doom and gloom for you. It's not intended to be, but I think if you're, these are areas that I find a lot of not-for-profit organisations either don't have the resources to sort of put in place some strategies, and or it might be that it's just something that you don't have time to do. So, but once you become informed about these things, you can make a decision then and make a proper assessment about how you're going to deal with that risk. So thanks. Oh, yep, sorry.
Just one question.
Yes.
Oh, sorry. Just one question. You can apply the copyright symbol without going through any specific process?
Yeah, so it's as I said, it's optional, and you can put it on there to declare that you own the copyright. If you don't, that's not going to save you. In fact, you'll probably get done for misleading or deceptive conduct. But if you can put it on at any time. And it's really important to say there is no registration system, at least not in Australia. There is one in the US, but it's not even. It's not an obligation to register it through the US one. And it doesn't mean that they own the copyright. It just is a way for them to assert and record their rights. But it's automatically created. As soon as you create that works, it becomes copyright. So,
thanks.
No worries.
I hope this isn't a rude question.
No, that's okay.
Say a very basic corporate logo and name trademarking, roughly what would that cost to do?
I was going to say it depends. It does depend on who's doing it. So there are some large organisations that will offer pro bono services. I take on one pro bono client a year, and then I discount my others. I discount for not-for-profits on a fixed fee basis. So but realistically, you'd want to be budgeting around the sort of $1,500 mark, including all the government fees. And then, it kind of then again depends on your budget. So there's things that you can skip. If you have been using it for a while, then skip the brand clearance and take the risk, because it's not going to stop you. You've been using it for 3 years. You're not going to be at risk of infringement. So skip that process and you've just halved it. Things like that. Yeah. Hey. I'm just getting blinded by that light up there.
Thanks for the presentation. I run a graphic design social enterprise, so we deal with a lot of this. And in relation to copywriting, and particularly in relation to ownership of materials, we always tell clients that they own it, but we don't have it in our terms and conditions. Yeah. It's kind of an unspoken thing, and when they come and ask us, we tell them it's theirs. Yeah. We also ask their permission if we want to use it on our website or anything like that. But should we be putting that into our terms and conditions just to make it more sort of defined? Yeah, so
they call it an assignment. So an assignment just means it's a transfer of ownership. from one to the other. So if it's not, for an assignment to be considered effective, it has to be in writing. So, and generally signed by both parties. You can get away with it. Usually if you have some good terms and conditions and it states in there that, you know, upon creation of the copyright material, which may not be some of the underlying artwork stuff that you do, but it, you know, it will be the finished product and it will be the logo, then, you know, you want to actually expressly state that in your terms. And it actually, I found it adds a lot of value for graphic designers to state that in there because it shows that you're respecting their work. And I mean, they have an implied license, but you actually will still be the copyright holder on most of those. So, yeah. Cool. Okay. Thanks, guys.